Hello, my name is Jonathan Swift and welcome to the latest episode of Insurance COVIDcast. Today we're looking at insurance trials under lockdown and how lawyers and insurers are managing cases and claims whilst locked out of the courts. I'm delighted to say joining me today I have BLM partner Jonathan Clay, Kennedy's partner and head of motor Ian Davies, Market Study Group Head of Claims Steve Cross, DWF Law Barrister and Head of Advocacy Jonathan Robinshaw, and finally DAC Beechcroft partner David Williams. Welcome, gentlemen.
Thank you.
Good morning.
Good morning.
So to the point, and first question, and I'll come to you first of all, David, just because you're the top left of my screen at the moment. David, how have you found managing existing cases and claims whilst in lockdown, and how has technology helped you do this?
Well, at DAC Beechcroft, we've had an agile working policy for about 5 years. Many of our employees chose to work from home occasionally before the COVID-19 pandemic, and everyone already had a laptop and a soft phone. So to that extent, we were well equipped. We've been electronic working for 8 years. We've had an e-sign system, which we introduced through our innovations lab in January, which enables clients and witnesses to sign documents without printing or scanning them. And we'd already launched some customer care animations, which guide clients and witnesses through the claims process, even though we aren't able to meet them face to face. As a business, on the evening of the 16th of March, our managing and senior partner instructed all our staff in England, Wales, Scotland and Northern Ireland to work from home, save for a small team scanning incoming post. And that's worked very well. Our virtual in-tray, electronic files and agile working has enabled us all to continue to work from home without difficulty. And our clients have said it's effectively business as usual. Alongside that, remote medical examinations have enabled our complex injury team to keep claims on track to joint settlement meetings. And of course, if settlement isn't achieved, a face-to-face examination may follow. But during lockdown, the use of technology has meant that we are pretty much business as usual.
Ian Davies?
Yeah, a very similar story from our perspective. We've certainly been working from home pretty much since the Thursday before the lockdown. As with our global presence, we've sort of seen this sort of coming across the globe and had taken various steps to make sure we were ready in the UK. But similar to everyone on the call, we're remote working, we're agile, we have people working from home anyway. So it's been pretty seamless from our perspective. Everyone's just moved along, and our clients seem to have been able to continue getting instructions to us and us actioning them. So it's not been too much of a challenge. On a slightly more positive note, I was watching a video yesterday from our Hong Kong office who have gone back in. So some hope for us all maybe in terms of returning to that degree of normality. They were obviously some of the first people out, but we're now some of the next movement of people going back in, and everything's continued working and functioning there. So fingers crossed for us all and society as a whole, we can take their lead and head back towards the office. I suppose the ongoing question now probably for us all is, will we be going back to the office full time, and will our working practices amend and change so that working from home is more prevalent, because the systems work, the structures work, it's resilient. So I personally think we'll probably see a bit of a change in that approach to working from home.
Steve?
Yeah, similar story really. I mean, we took a very proactive stance on this one, seeing what was coming, and we had our whole claims function working from home about a week before the lockdown. So for us, it's pretty much business as usual. We're embracing the technologies. We've got a fully image workflow system, so we don't need the people in the office. Even our large loss team are managing without full access to paper files, because we have a full record on systems, and they're adapting to those new working regimes. Great use of video calling, as we're doing today. I mean, it's all team meetings are now done by video, and to be fair, I think I'm most probably talking to my senior team more than I ever have done. You know, we got at least one daily video call in. So if anything, I think it's bringing people even closer together at the moment. But as Ian said, I think we share a similar view now. I'm almost starting from the premise of why do people need to go back into an office? And I think if the industry looks at it that way, I think there's some great opportunities, because I think we're proving that remote working and agile working is very viable. So yeah, I mean, it's obviously we'll come on to talk about litigation, I'm sure, but from a day-to-day perspective, we are seeing it pretty much business as usual.
Jonathan Clay.
Yeah, I think picking up on Steve's point there about the question about why should we work in an office, I think is at the forefront of our executives' mind in looking at how we go back. But picking up on the people thing again there, isn't it fantastic, the resilience that people have shown in our own teams and from our perspective in our clients, the way that we have all adapted to this remarkable change, because it is an extraordinary moment in our lives, isn't it? And for us to be talking about business as usual, would everybody have been that confident? We all have our plans and everything, don't we? But for to see it as effective as it is in our business and from the other businesses that are here represented today is absolutely fantastic. And I think that's a tribute to the to the people fundamentally, isn't it, involved in on all sides. So that's terrific. From the more operational side of things, our experience is very similar to that recorded, which is that things are moving in the right, are working well. There's good experiences. I think particular reference to the ABI agreement and the practice direction have facilitated very much the effective working between the parties. That was picked out by a couple of my colleagues when sort of canvassing views on all of this. The remote medical examinations, there was a lot of skepticism in certain quarters around that, but that's finding its place and finding a way forward and being very effective. I think there's a nervousness a little bit about certain backlogs starting to build in courts. I don't know how many people are in courts actually active or how many are working from remotely. I mean, they've evidently done a fantastic job in keeping the show on the road as they have done. But I think I'm getting some anecdotal stories now about some backlogs building up about cases being not yet being issued. And also it's noticeable in our scanning rooms, there's a very large proportion of the paper coming in is from courts. So, maybe that's something for the future to consider. So, yeah, I echo probably what everybody else says. And it's interesting to hear. It's a shared experience.
Finally, I'll come to you, Jonathan Robinshaw.
Yeah, I think we've all touched upon it, but I think the entire legal industry was preparing for agile working, or certainly streamlining litigators' processes with case management systems, centralized document production teams, online resources for many years. Litigators have long time had all the tools they needed to progress claims just with having a computer screen. I think what we've all touched upon, especially Ian Davis, was suggesting that I think really the pandemic has just accelerated the process that we were already undertaking. All agile workers at DWF had all the sort of hardware system and the support in place. I think the investment, very quick investment, simply in relation to server capacity, and that's something that those within the relevant departments got together very quickly to sort out. It was very impressive, but surprising really how quickly in that first week we all were back to work as we had been. The only thing we didn't have was the colleagues sat around us, just our children under our feet. Same kind of distraction, I suppose, colleagues and children, but that was the only real difference. And our legal business is like all others. The fee earners were very quickly back to litigating and progressing claims. I think that one difficulty we had was that seamless transfer of instructions from the insurers. I think the insurers were a little bit it took them a little bit longer to get back to full working capacity. And I know Nigel Teasdale, who's the head of the motor fraud practice group at DWF, was working very hard with the clients to try and assist them with their working capacity and try and get the instructions moving a bit more smoothly. I think all that we're really missing from the process is a bit of human contact, isn't it? And the sort of camaraderie of office working. I know a few people have touched on it, but across DWF, I think we've been trying to use video group calls as much as we can, keep in touch, host team meetings, technical seminars, even do socials and pub quizzes to try and maintain some sense of normality. And I don't think any of us can say business as usual. It's certainly very unusual, the circumstances that we're within, but as long as we're servicing the clients and progressing claims, it's working well, but it's certainly not normal, is it? The circumstances that we're working under.
Can I ask Jonathan Robinshaw, have you been involved in any remote trials, mediation, dispute resolution? And if so, how have you found the remote experience?
Yeah, so I'm a barrister as well as being the head of the advocacy team. So I've been conducting trials, interlocutory hearings throughout the pandemic environment. I think one area that insurers, litigators, and probably the public has got some awareness of is the possibility of fraudulent claims or dishonest claims, farmed claims slipping under the radar in this sort of pandemic environment. And challenges, can we properly test those types of cases when we don't have access to the court or the similar access to the courts that we normally have? I know Lorraine Carolyn, who's the national head of counter fraud at DWF, has been very keen for her team to adapt what is their renowned abilities in hunting out dishonest claims, rather than just giving up the fight, to use these new platforms or remote means to still put claimants in suspected farm claims under that spotlight of cross-examination. A recent example of the success of that has been through Jules Chamberlain's team. She's head of the validation team at DWF. She elected to agree to one of her suspected farmed claims to go to a trial via remote means in Manchester County Court, heard on 7th of April before DJ Osborne. And under cross-examination, ultimately the claimant admitted that via a cold call, he was coerced to make rather more of the accident and his injuries than was actually the case. And despite there having been a very minor accident and some niggling injuries, the judge dismissed the entire claim, owing to the fact that he had, via this cold call, agreed to pursue a dishonest claim by making more of it. That's a very good example, I think, of how remote trials are still working to hunt out those dishonest claims. The sort of types of hearings as well that we've been doing are ones that we've been doing remotely via the court's telephone practice direction for some years, the sort of interlocutory and more straightforward hearings. It's really only the trials and perhaps more high value interlocutory cases that is new to this sort of remote means. And I think some are going very smoothly. Some district judges are, I think, perhaps rightly wary of whether or not they can assess credibility in the usual way without seeing the claimant or indeed other witnesses or indeed the defendant in court, seeing their body language, how they behave during other people giving evidence. It's very difficult, I think, for a judge via remote means to be keeping an eye on all the other witnesses, even if they can see them, while other people are giving their evidence. Their reactions are normally very key to that assessment of credibility and whose story better fits perhaps what is more likely to have happened. So I have great sympathy for judges trying to determine remote trials in claims that involve some element of veracity or credibility of any one of the witnesses or the parties. But generally, my experience is it's proceeding smoothly. We're assisted well by the DWF fee earners who have adapted to efficiently compiling the electronic bundles for the court, getting them in good time to ensure the judges have all that they need. That was a niggling issue right at the beginning, as you'd expect when you're in person, you can throw up and hand the judge anything that you may have that they don't have. Obviously, it's a bit more difficult remotely. I have to say, judges have been incredibly accommodating with barristers simply emailing documents to them during the course of the trial. Fundamentally, they want to ensure that justice is being seen to be done as well as being done. So they don't want a party to assume that they haven't seen anything or properly considered everything. But I have to say they're being remarkably accommodating.
David Williams.
Yes, I suppose we've had a number of trials. We've had hearings in the Supreme Court, the Court of Appeal, Court of Protection, and they've gone very well. The Supreme Court are using Cisco, Court of Appeal and Court of Protection, it was Skype for Business. And through good preparation and preparing for WhatsApp or text message to be used to pass notes to counsel, they've gone very well, and the senior associate in the Court of Protection described it as smooth as could be expected. There have been a few glitches. One of the judges had problems with the microphone in one hearing, which meant there were difficulties hearing his questions. And perhaps more amusingly, an advocate in another decided to use the conservatory for his office. There was heavy rain, and you couldn't hear him for the rainfall on the roof. We've also had JSMs and remote mediations. We've settled a number of complex injury claims using Skype, using Zoom, using life size. One mediation was 7 hours long and had been arranged before the lockdown, was held on Zoom and settled. I think the key is preparing for these things, as Jonathan has said, with advocacy, making sure that you can share the documents on screen, making sure you have the separate meeting rooms set up, and making sure that you know how you're communicating with the other side to get them into the common room to discuss things and settle. I think at the moment we're feeling our way. Remote JSMs, remote mediations, remote hearings by video certainly are novel, but given the cost saving they present, the avoiding of travel, and the fact that people can be available more when they aren't needing to travel, it will have a great impact, and I think they'll be used more often.
To you, Ian Davies.
Yeah, very similar experience across all practice groups at Kennedy's. JSMs, hearings, all progressing well. We're not seeing any unexpected results. We're certainly not discussing sort of appeals or anything on the back of any issues that have been created by the hearings being conducted remotely. So we're embracing it, and I agree with all that's been said, that there's a reduction in travel time. I think it's focusing the minds. Certainly my own experience has been that issues that needed to be discussed and narrowed have now been discussed and narrowed, and we're cutting to the chase, was a comment made by one DJ. And I think that's beneficial to all parties, and our insurer clients as well as our own advocates. There's been plenty of cats on screen, as Jonathan's currently struggling with. But that happens, and everyone's dealt with it with good humour and have been very sensible about it. And I think there are compliments due to be paid to the judiciary who have battled through, and we all know that the courts are not necessarily new buildings very often, or indeed designed for modern technology. And it's been good actually to see the parties working together and collaborating to get things moving forward, because we've all got that concern that there's going to be a backlog, that's going to impact on life cycles. It's going to have operational impacts on insurers, law firms, claimant law firms. So moving them forward is important. And like Jonathan was saying, we've had some complex issues that have run and gone well, and we've had some pretty straightforward ones. I think there's certainly an opportunity here for sensible discussion and sensible adoption of some of these processes going forward that will benefit all parties.
Steve?
Yeah, I mean, I agree with a lot of what the guys have said there. I mean, as Ian was saying, I think the the legal profession and the courts have adapted brilliantly to this, and I think, you know, we've been involved in some successful JSMs, you know, and they, you know, it is easy to set up separate rooms with the technology we got available to do those, and yeah, I mean, we've been involved in a few litigation cases, and one fast track case that, you know, Jonathan was talking about. I think it is one that is worthy of note. That was actually a marker study case, and whilst we were really pleased with the fact that causation was dismissed and the claim was thrown out, the one thing I still question is, if it had been a face-to-face trial and the claimant had been in court, would we have got a fundamental dishonesty decision on that one and a ruling? So I don't know if we would or we wouldn't have, but it does throw open a few questions around, you know, whether you'd want to get any claim involving fraud or fundamental dishonesty done remotely. You know, I think it, for me, it does have its limitations on what it can do, but it's definitely, I mean, again, the industry and the courts are proving that there is a future for this type of process.
So finally, I'll come to you, Jonathan Clay.
Well, I'd probably repeat what the colleagues on the call have had to say. Preparation seems to be key, together with a strongly well-managed case by the judge, and the adaptation of the courts to this has been fantastic, hasn't it? And the adoption of it. I think in the early days there was some frustration about a lot of adjournments being just automatically produced, but then it started to backfill and it started to move forward, and we're getting dates in. A colleague of mine has just finished a 4-day stress case, you know, and waiting for judgment in 10 minutes time following that, you know. So and those are the sort of cases that everyone would have gone, oh God, no, you can't possibly do that. Well, you know, maybe we'll find out in the judgment we should. But all the suggestions are that it went well. Everyone was very satisfied with the way the case was able to be heard properly and, you know, on time and everything. And it is great to see an ability to, for the non-trial bit, for the mediations, for dispute resolution, for JSMs and the like, we seemingly can get them in the diary much quicker because of the amount of time that suddenly is freed up in people's diaries amongst experts and counsel and busy lawyers and insurers as well. So I think that's a benefit to some of the cycle time problems that we're probably enduring at the other end of the equation. But remarkable to see, really. But technology seems to be the key, and some of my colleagues seem to think they need 3 screens to do things effectively on this sort of thing. One of them advises very strongly he switches off his own face because he can't stand looking at it for 3 hours at a time. And but he would also say that he ate fewer biscuits and drank less coffee by doing it remotely than sitting in the council's chambers or whatever. So, but it's very, very positive responses really since lockdown on this. Yeah.
Can I ask Jonathan Clay then? I know the Civil Justice Council has requested feedback on the impact of these remote hearings. Do you think, depending on what that feedback finds, that these will become, you know, more prevalent post-COVID? And if so, what cases and claims?
Right. Well, there's the consultation on this opened on the 1st of May, didn't it? And it's the closing date for it is the 15th, so that's not long away now. And some of the preliminary discussions seem to suggest that remote hearings are positive in some of the complex commercial cases. Now, so positive feedback around that. Now, and that might be something to do with the fact that the technical court has for a long time had a lot of good technology in place for those sort of cases. So maybe they're used to doing that. Interlocutory matters run very well. Some people will say to me in conversations that they find that it's not always necessary to have video. You can use telephone, although a long telephone call can be extremely hard work, if you like. But everything doesn't have to be video. But interim. Remote hearings in terms of negative experiences, some people have experienced them around lower value cases, and particularly with litigants in person, sometimes around the lay evidence being presented. But equally, I suspect perceived wisdom, such that it is around this, because it's all very new, isn't it, in many respects, is that the lower value cases might be the ones that are more akin to having video and remote trials and the like. But having said that, there's a lot of the issues that the guys have already identified here around fraud and the like that are in those lower value areas. So there has to be a degree of so there's a mixed picture coming back, as I understand it, to the CJC around what will and what won't be appropriate for the future. But I think there's a concern, or one that's been articulated to me, is that let's not fool ourselves. What we've done here is adapt very, very quickly, bolted on a lot of very, very good kit onto what still remains a 20th century and in some cases 19th century model. And we do need a digitalized model for the future with all of this built in. The practice direction, the ABI agreements, all those sort of things that facilitated us moving to this position that we've achieved, which I think by very common reckoning is very pleasing. But from a going forward perspective, there's still a lot of work to do around that. And in some respects, that speaks to the point made a little earlier about the amount of posts still coming out of courts and the like. And I'm not critical of courts in this. This is just the way it is. But thinking that the Rubicon has been crossed and we're over there and we're fully conversant with it all, I think would be a mistake. But we are moving away from that sort of tyranny of paper that Lord Justice Briggs talked about when he was talking about online courts and online dispute resolution. But we aren't at the Susskind end of things yet with the idea of everything being done online and the like. So good steps, things that can be done. I'm sure there are positives that will be drawn out of it, but I mean, building the infrastructure underpinning it all is pretty critical.
Steve?
Yeah, I think Jonathan Clay's summed that up very nicely. Actually, I think for me, I think I think that there will be permanent changes. I think it's inevitable that there's going to be permanent changes to the court process going forward. And I think we've all got to embrace that. I mean, it's the future. Technology is going to be the future. And as the courts want to get into more of a digital solution, it seems then madness that you go down a digital solution that then you all go around and sit around in a court for every single case. What I would say, though, is I do feel quite strongly that this won't be suitable for all types of claim. And when you're talking about particularly complex claims with huge amounts of documents, lots of witness evidence, etc., I think it will, with the best will in the world, it will become more challenging to try and do that remotely long term, particularly as you get more and more of these cases. At the moment, we're in a time where there aren't loads of these going through and people have got more time because there aren't so many accidents happening, there aren't so many new claims coming in, so everyone's got more time. In a world where we go back to some sort of normality in volumes, it will become more challenging if you're putting all of these cases through that type of scenario. And and certainly anything in relation to fraud and that type of thing, I think you need that face-to-face participation. Otherwise, I think, well, apart from anything else, from a fraud perspective, I shudder to think what tactics the fraudsters will come up with from remote when we wouldn't be able to be sure that it'd actually be the genuine claimant giving evidence. So I think there's certain things we need to factor in. We can't go crazy with this and try and get every single type of case going through this sort of technology, but certainly there's a place, and I don't see how it won't be permanent to some sort of degree.
Yeah.
Okay. Jonathan Robinshaw?
Yeah, I think that's very sensible. Certainly what Steve's suggesting, and it would be right for some, but not for everything. I think the legal system, from a barrister's point of view, has been working towards creating that sense of atmosphere within court in order to extract the information that's necessary and required via cross-examination. And developing that sort of atmosphere in remote means is quite difficult. It's a new challenge, and speaking to a lot of colleagues and friends at the bar, it's a new experience. We're having to go back to basics and sort of learn afresh how to develop certain points via remote means. And I think what Steve's saying is what we're all fearing as well. Who's behind the screen giving prompts and comments to someone giving evidence, then that can't be moderated without having somebody from the court service at the individual's home. You can't stamp out that sort of thing. What we've done is very quickly and very well adapted to an incredibly difficult and challenging situation, but it's far from perfect. It will help us, as we've discussed on this call, via consensual and mutual dispute resolution via ADR and arbitration. I think lawyers utilising the platforms more is a good thing, and that will be utilised more going forward, I'm sure, rather than us all having to traipse to somebody else's office, set up camp. I'm sure we will use remote means a lot more. Whether or not we use it more at courts, I'm not entirely convinced. I know from CJC standard that we're looking at two things. Can they use this to access, increase the access to justice? Certainly for litigants in person, they'll become more and more part of the system when the whiplash reforms finally, they're given parliamentary reading time next year, and you'll have more and more litigants in person trying to access the court system, and whether or not via remote means will increase that access to justice. I think they'll be looking at that carefully. A decrease in costs and travel time is great for all involved. Certainly those insurer clients of DDRF are looking at that very closely. The cost savings are huge at the moment in terms of their lawyer spend for travel, accommodation and such for those longer trials. So I think it will be utilised. There's a place, but I think some care and degree of caution has to be used in saying that this is the holy grail to resolve all issues in litigation now.
David?
I echo the comments of the others. I suppose the first thing is remote hearings aren't actually that new in some ways, in that we had telephone hearings of interlocutory matters of up to an hour, and we've had those for a number of years, but now we've got much longer applications and trials and higher courts cases being heard remotely. One thing that has caused some problems is the way that the courts have introduced local guidance notes, and guidance notes which differ not only from court to court, but in some courts from judge to judge. And we're seeing some courts accept large bundles, 20, 30 megabytes, others saying 50 pages is the maximum you can e-file. If we're going to work with electronic hearings and remote hearings in the future, we're going to need some uniformity in the rules and practice directions. But long term, there's no reason why we can't do so much more remotely. As everyone says, saving travel time. There will be some cases where we need personal attendance, but remote hearings, I think, will be here to stay for a lot of it.
Finally, I'll come to you, Ian Davies.
Yeah, thanks, Jonathan. I'd again echo what my colleagues have said there, that obviously they're going to be here to stay. I think that the case where you want to look the claimant, the expert, in the eye will remain and should remain in place and in person, because that's a fundamental part of the process. I think going to the other end of the spectrum, we have, and David's touched quite properly on the variation in practice directions that we're seeing around the country. But there's probably one set of local practice directions that maybe pave the way forward in the low value claims, and that's the practice directions out of the Newport, Blackwood and Merthyr Tydfil courts in South Wales that have already and long established MOJ stage 3 hearings by telephone. From Steve's perspective in the insurance industry, it's madness to be paying travel fees for what amounts to a 10-minute hearing when parties are represented. A DJ can deal with those. Yes, there needs to be some work and organisation around essentially waiting to enter chambers to address the judge, but that's not in any way insurmountable. And you could see that really picking up and having whole lists then running quite smoothly, and that could be advanced quite easily, I would suspect, into the non-contentious, low-end, fast-track, maybe quantum only, maybe the parties in terms of access to justice and seeing justice to be done want to be in the room together and want to have the opportunity to to see their opponent give evidence in a liability dispute. I get that and would support that. But I think there are certain areas that, with a degree of collaboration and forethought, we can maintain, advance, and improve what is already a good process that's been, as colleagues have said, accelerated purely because of the situation we've all found ourselves in.
Can I ask you, Ian, do you think there is a perception issue, though, that people might not get the access to justice or the same fairness from a remote hearing in person? Because I have heard about people saying that the use of technology can be particularly tiring, especially in long cases or long hearings.
Yeah, I suppose, speaking personally, and we all in our practice areas travel extensively, so it is a long hearing by video or telephone more tiring than a 4 a.m. start, 5 a.m. start from our chosen local station. So I think I'd throw that in from a personal perspective as somebody who racks up a lot of miles. I don't think so personally around the tiring point. I think it's just an adjustment to our working lives. As far as the perception piece is concerned, I take that on board entirely, and I think where it's a particular case that a party wishes to see justice being done, I think it's important that they retain that right. But where we have advisors, both to the claimant and the defendant in this side of the fence, where they know each other, that they respect each other, they understand how they're moving forward. I think there's common ground there in those cases, and there will be on both sides a requirement to maybe manage client expectations. But as Steve has said, we in the defendant side, of course, would want to, would not want to give up the opportunity, and Jonathan as counsel obviously wouldn't want to give up the opportunity to cross-examine that claimant on the specific point in person. So that should remain. I think there will be opportunities to have both, really, and that should not be a challenge for all of us to work towards.
Steve?
Yeah, I think this is human nature, isn't it? I mean, whenever you embark on something new like this, there's always going to be people that are sceptical about whether it works or not. And I think, the fact is, it just needs to prove itself. And once it proves itself, and you've got enough of these cases going through, then people will trust it and will accept it as the norm. And I don't see why these remote hearings should be any more tiring than being there in court. I think I would question whether it's just a case of people having to concentrate a little bit more, and that can't be a bad thing. I don't. I do agree. If you're actually attending court, you've got the travel, you've got everything else, and you've got that daunting experience. That being remote has got to make it a little bit less daunting for those that particularly aren't in the legal profession. So yeah, I think people will get used to it very quickly.
Yeah, Jonathan Clay.
Yeah, I think it's probably a question of getting used to a different dynamic, isn't it? I've heard people saying that it is exhausting, a 3-hour focused thing on particular poring over certain detailed kinds of things, but it's I think it's probably just getting used to things. I think there's interestingly, does this give greater access to certain parts of the community, people with significant disability? Are they going to be able to have more access to the courts by this route rather than having to schlep to Oldham County Court or something like that? It's so it comes with a benefit in that regard, perhaps. Litigants in person, maybe it comes down again to something I think a number of people have made a point about, that the strong case management by the judge, so that people feel confident that they are being heard. I mean, that's an important feature probably, to ensure that the perception is addressed. So because in live court, there is a lot of effort made for lay people, for litigants in person, to be given enough understanding, or ensuring that they have a full understanding of what's going on. Because amongst lawyers, we tend to try to know that, don't we? But amongst those that aren't more used to that environment. But equally, then there's some feedback around the issue of respect for the solemnity of the occasion, if you like. Now, it sounds a bit pompous, doesn't it? For which I apologise, but it's a serious business trial, and the judges require the level of respect. And I've had some anecdotal information that suggests that some less than respectful noises have been made at judges. Now, whilst that might be a common thing to hear in certain types of courts, in the civil courts, that isn't necessarily what we hear too often. So there are some things to work through, but as I think, going back to Steve's point, it's something new. It's getting used to it, and we all started in different places at different times. So I think it's possibly a lot of it is around familiarity of experience.
Jonathan Robbinshaw.
Yeah, I'd agree. It's definitely adaptation, isn't it, to this new means. And from a barrister's point of view, maybe even the bar course will have to adapt and have a module on remote hearings. How do you deliver submissions in a different style, or how do you adapt your cross-examination? I'd rather suspect that some claimants or witnesses actually may prefer not to have to appear at court and be face-to-face with the pageantry of an in-person trial. But I think in some occasions that's important to maintain that pageantry, the wigs and gowns, or even in some fast-track trials now, not even that, but being within that atmosphere, creating the right aura, I think is important. And I think that sometimes is the entire perception of gaining justice, doesn't it? And what's often said, perception is reality to everybody. If the parties feel like they're not getting that day in court, as the phrase goes, we always hear, when your client wants their day in court, and they're not going to get that, will they come away from that, obviously, if they're not successful, feeling that they didn't have the opportunity that others have had before them, or can some people still have to this day? I think that is a real danger. I think the two biggest dangers from perception for me are in relation to the cross-examination. And if you're representing a client and you're cross-examinating of a other party isn't perhaps hitting as hard as it might in person, will they feel that they're not getting justice, they're not having the opportunity for their case to be properly put to the other side? I think that's a real problem of perception. But also from counsel's point of view, it takes sometimes that in-person appearance before a judge to build that repertoire, to build that connection and relationship with a judge during the course of a trial that sometimes you'll need at the end when you're perhaps making some creative submissions. You'll need to know a bit of their personality to see what you can get away with, what you can say, and how you should phrase it. And that's difficult in a remote means to sort of gain that perception from judges. I think a lot of us will agree that we're perhaps quite different in person than we are remotely. I think you've got a bit more of an opportunity to think about how you're appearing, because you can see yourself in the mirror screen, your face expressions, even how you're sounding. You're given that opportunity to be a bit more wooden, I think. People are thinking more and more about it. So judges are harder to read. I'm sure counsel are harder to read. Witnesses are harder to read via remote means, and that could affect the perception. I think if I could offer an alternative view on the tiring point, I'd say actually conducting a full day's trial as counsel is tiring in itself anyway, in person. That level of concentration, I've always said it's akin to being a snooker player, because even when you're sat down, you're not resting. You're like the snooker player, waiting for that opportunity to get back up again. And you're constantly listening to what everybody is saying, even if you're not making a note of it physically, you're making a note of it in your mind and thinking how you can turn that either in your closing or put it to a question in another witness. So you're constantly not just paying attention, but actively listening to what's going on. And via remote means you're doing that, but you're also, flicking between three screens, getting documents up, having perhaps different systems running, accessing documents from your client's own case management system, etc. So I think that added concentration on tech adds to a sense of fatigue as well. So from counsel's perspective, I think it is a little bit more tiring, but as we said before, this is Steve saying, it's about adaptation and getting used to it. I'm sure once we are established in this means, it will be second nature flicking through the electronic means. The Supreme Court only has electronic means. That's some counsel are just entirely used to an electronic based practice. But all of us are being forced into that. It's sort of, as I said right at the beginning of this, the pandemic has accelerated the pace of that progression to force us all to utilise it a bit more.
Finally, I'll come to you, David.
Yeah, on the tiring nature of the hearings, it's worthy of note that the Lord Chief Justice and the President of the Family Division have sent a note out to judges commenting on how more tiring it is for them. And that's understandable. They're staring at the same screen all day rather than looking around the court. They're having to appear to be listening to everything that's being said, as well as listening, and they're having to concentrate on the screen and the documents. One thing that may do in the longer term is lead to shorter lists and delay in the progression of litigation. As to whether you get the same access to justice, a number of hearings which would have been in public have taken place in private to allow the technology to facilitate the hearing, and that's impacted on public access to the courts, potential future parties being able to sit in hearings, and access to the hearings for the media. There's also the question about whether litigants feel they've had second-rate hearings. They can't look the judge in the eye in the same way, and there has been some feedback on that. I suppose if we're going to stick with remote hearings for trials, more thought about backgrounds and what is going on ought to be there, because looking into the judge's house doesn't give the same formality as sitting in the courtroom with the shield above his head. That said, if you have a choice for remote hearing or a significant delay in proceedings, many will prefer the remote.
Okay. Well, on that note, I'd like to thank my panel today, David, Steve, Ian, and the two Jonathans. Thank you very much, gentlemen.
Thank you.
You're welcome.
Good to see you all. Good to see you all.
Cheers.
As I mentioned before, this is part of an ongoing series, Insurance COVID Card, brought to you by Insurance Age and Insurance Post. If you want to register or subscribe, then please use the tab in the banner above here. So for me and my cat, goodbye and stay safe. Cheerio.
Bye-bye.
Goodbye.
Thanks, Owen.
Bye.
Cheerio.